Very welcome to this brand new AI breakfast. I am very pleased to welcome you, not in a meeting room as such, but again in virtual mode. It allows us to have more persons on board, and I'm very pleased to welcome you to this new, breakfast on a topic about predictive policing and rule of technology. There is algorithm almost everywhere in our life, and these algorithms are more and more used for policy making, decision making. So we will discuss our guest about that. Juliette?
Thank you, Yannick. Good morning, everybody. I'm very happy to be with you this morning, and I will introduce our three speakers. Our first speaker is Marine Kettani. Marine Kettani is a French magistrate. She works as a policy officer at the French Ministry of Justice, where she is in charge of innovation and technology issues. Marine is also a representative to the CARAI, ad hoc Committee on Artificial Intelligence at the Council of Europe, and she's following here multiple projects involving artificial intelligence and other technologies in the judicial field. Our second speaker, Christopher Markou, is a Leverhulme Early Career Fellow and a lecturer in the Faculty of Law of the University of Cambridge. Christopher lectures on economics of law and regulation and directs the Artificial Intelligence Law and Society, LLM, at Dixon Poole School of Law in King's College, London. He has written widely on matters of law and technology, with his work featuring in Scientific American, Newsweek, and Wired, among others. Our third speaker is Mrs. Antoinette Rouvroy. Antoinette is a senior researcher at Research Center Information Law and Society, which belongs to the Faculty of Law of the University of Namur from Belgium. Her research deals with the issues of polycentric governance, normative technologies, and the articulations between legal, technological, and social normatives. So all three speakers will give an introduction to their themes in about 10 minutes or more.
Thanks a lot. And also we are very pleased to have an introduction by the chairman of the Parliamentary Assembly, Mr. Rick Dams, and we will give him the floor now for a short presentation.
Good morning to all of you from Strasbourg, from my office. I'm very glad that I can have a short introduction to this event. As you all know, the Council of Europe is all about standard settings, monitoring, and doing this within an international cooperation. And our field of action, obviously, is human rights, fundamental freedoms, rule of law, and democracy. So this is something that interests us as a parliamentary assembly enormously. If you look at it from a SWOT analysis angle, and you take the long term in it, you see that there either are opportunities and threats. Of course, we have to grasp both of them. We also see that artificial intelligence is increasingly being used by public authorities, predictive algorithms and what have you. And of course, the quality, the output of the algorithm is on the one hand, it is based on the data that gets into it, but also on the other hand, the one who programs the algorithm. I mean, the way you look at it, this is one of the tricky parts. And for example, one of the threats that's in there is like, for example, racial bias. I used to say facial recognition should not become racial recognition, and I welcome to a certain extent IBM, Amazon, Microsoft, the cities of San Francisco, Boston, who put a halt to it, at least temporarily, until, and this is my position also, until we have a set of rules and regulations that protect these fundamental rights, these freedoms, democracy, and what have you. So I'm not against artificial intelligence being used for the good of the people, for the citizens, but I do think that from a political angle, we need to have a set of rules that protect these fundamental rights, these fundamental freedoms, and these rules are not in place today, which has as an effect that a lot of artificial intelligence today is used in a my view, in an improper way. So regulating is very important in this field. As a politician from the Parliamentary Assembly, we need guidance, we need expertise. This is why I'm very interested in the event of this morning and all the other ones coming. And you also need to know that the Council of Europe is a front runner in these kind of issues. And we can use, out of the Parliamentary Assembly, let's say, the tool of a recommendation to be handed over to the Committee of Ministers, who then can use this to make a recommendation, use guidelines, who knows, even a convention on artificial intelligence. At the end of the day, we are preparing a number of reports on this, and for your information, in the October session, and let's hope it can go through, we have a full day consecrated to artificial intelligence. So any input that you can give us additionally to have that full day on artificial intelligence would be very useful, because at the end of the day, out of that one day artificial intelligence debate in our Parliament Assembly, we'd like to distill a recommendation to be handed over to the Committee of Ministers to deal with it in the future. So thank you very much for organizing this event. Thank you very much for having me on board. We might use artificial intelligence a little bit, you know, when you see your lips move, that the unmute button would go automatically. Just I'm giving. I mean, that would be a good example, obviously, of artificial intelligence. I can think about some other ones. Still, again, thank you very much for having me to introduce this event. I'm very interested. I'll be on board. I hope that I can put some questions also, if I got some. Well, Patrick Pennings knows me. If you have me go, I'll have 150 like at the first, and then so much more. But still, it is very valuable to us to have your expertise, your guidance in this enormous field, and hopefully that we can get a number of these informations on board in the reports we will discuss in the October session, and again, out of which we wish to distill the start of a recommendation. As you know, we believe that we, the Parliamentary Assembly, are a little bit the cradle of conventions. It's a bit pretentious, I admit it, but still, it is a bit true. And so if we can have this in a recommendation, hand them over to the Committee of Ministers, who knows, at the end of the day, we can start working on this standard setting, which is so important to grasp the opportunities in this new technology, but on the other hand, to protect us from the threats. Thank you very much. Lots of success, and I'll be on board.
Thank you very much, Mr. President, for this introduction. We do indeed need a set of rules on the use of artificial intelligence in the field of policing and justice. Now, we'll be able to go into more details about why we need these rules, this regulation, and how this regulation could be shaped. So, Marine Kettani from the French Ministry of Justice.
Thank you very much. So first of all, it is important to explain what we mean by predictive policing. The use of algorithms in the implementation of public policies is now commonplace and sometimes raises few questions. For example, who would now prefer to have their taxation calculated by hand by a human being rather than by a machine on the basis of predefined calculation rules that mathematically translate the provisions of tax law? However, these algorithms are traditionally based on predefined rules, which they apply. The implementation of public policies and decision-making by administrative authority has recently been enriched with numerical tools based on statistical learning methods. Thus, new forms of algorithms are increasingly being developed. They have in common to take advantage of large quantities of data, making it possible to implement previously limited artificial learning methods. Broadly speaking, what we can call predictive policing consists in the use of this new form of quantification. This calculation technique takes advantage of the development of massive data to allow algorithms to learn automatically characteristic structures in databases in order to extract classifications. And based on observed regularities, these computational devices rationalize the future by making it available for forms of preventive action. So what are the experiences in France about predictive policing? In France, we have specifically a few tools that use the previously exposed methods in support of public policies. For example, the gendarmerie services have developed a software called PAVED that aims at predicting vehicle damages and burglaries. So the machine looks at where burglaries and damages to vehicle have taken place in the last 6 years in order to deduct where the next ones are likely to take place. Hotspots are displayed in shades of blue and red on the map, and it indicates where an offense, burglary or damage to the vehicle, is likely to occur. That enables police forces to be visible in these areas in order to prevent damages. The first results tend to show that though the tool predicts correctly, from 83 to 85%, the places where burglaries are committed, the decreases in committed crimes is not significant with this technique. So we see that predictive policing is in a way putting into successive algorithms two major aspects of police action: knowing the crime and preventing it in a way that can be measured in order to ensure public performance. Another example comes from the General Direction of Finance. They use a system that analyzes and cross-checks the public databases and files in order to identify the files deserving a deeper analysis by agents in charge of fraud repression. It's called CFVR, and it's based on data mining and the learning from 20 years of tax inspection. It is said to have increased the chances of useful controls, as half the predicted files were followed by an actual inquiry, again 10 to 20% with former methods. So what are the benefits and risks to tackle with these methods? We must not deny the substantial benefits that this tool have been able to bring. Thus, this tool make it possible to improve the quality of services for users by making the action carried out by the service more effective. They can also offer greater equity in that sometimes extreme individual biases people in charge of handling cases can be mitigated by the use of such tool. Let's take an example. An agent would not imagine that a very elderly person could commit tax fraud. His attention could be drawn to the clues picked by the tools, enabling him to overcome this psychological barrier. Finally, it should not be denied that these tools are likely to improve the economic efficiency of the resource allocated to public services. However, these tools can generate significant risks for many fundamental rights, foremost among which is the right to privacy, as demonstrated by the decision of District Court of The Hague, which ordered in February to stop the Dutch government's use of the system Siri, which is an artificial intelligence tool to detect social and tax fraud. And the court considered that the legislation allowing the deployment of this tool was contrary to Article 8 of the European Convention on Human Rights, which enshrines the right to private and family life. It is also eminently important not to give up the task of making what predictive machines do intelligible for human beings in order to enable people to follow or not the prediction and to be able to contest afterward its appropriateness. Indeed, the more those tools are accurate and appropriate, the harder it will get to challenge the predicted results, as well as for the decision maker, as for the person who would like to challenge the decision afterwards. Analyzing the biases of machine learning algorithms has also become a field of research on its own, occupying computer scientists, mathematicians, and lawyers. Indeed, by relying on past data and decisions that may be subject to human bias, those tools can reproduce and disseminate them in a way that is much less perceptible to users. So what can we do for these tools? Do we need hard law? Do we need soft law? And what's the role of CAHE? Or multiple charters have already been written in order to regulate AI. We already have also some hard law, either sectorial or general. For instance, Article 22 of the GDPR states that the data subject shall have the right not to be subject to a decision based solely on automated processing. There is some exception to this rule, but we see that there is already some instruments to help us. We also see that there might be a need for a specific instrument to bring a global vision on this technology and to complete all the existing sector-specific regulation. In this context, the Council of Europe's Ad hoc Committee on Artificial Intelligence, of which I am a member, is aimed at examining the risks carried by this type of technology and the responses that can be made to them. The CAHE's mission is to examine, on the basis of broad multitaskholder consultation, the feasibility and potential elements of a legal framework for the development, design, and application of artificial intelligence based on Council of Europe standards in the field of human rights, democracy, and the rule of law. So maybe to conclude and to give the floor to the other speakers, the challenge is to find the right balances between innovations that are useful and regulation needed to protect rights and freedom. Let's take an example, an imagination example. Let's imagine that there is a tool capable of reliably pre-orienting a patient on the basis of a description of his or her symptoms, assessing his or her chances of survival. Imagine that this tool is able to detect serious cases that need to be treated urgently. It would relieve the daily burden on interns who sort patients at the hospital. Although, would we have agreed to let it select the patient who should have access to a respirator at the worst of the health crisis? That is the kind of questions we have to face today with these technologies. Thank you.
Thank you, Marine. And just to sum up, I think you raised some important questions, like some positive aspects that are presumed by some policymakers by the use of this algorithm, but also some risk. Of course, risk on human rights, you mentioned privacy, dignity, but also some issue to challenge, and I think it's important, this automated decision. And I'm sure that our next speaker, Christopher Markou, will have things to share with us about this kind of slight shift from rule of law to rule of something else, and I suppose rule of technology, as he mentioned in his forthcoming book. So, Christopher, the floor is yours now, if you wish to introduce us some of your thoughts about that.
So I have to do this at double speed and at 30,000 feet because I'm very bad at paying attention to things, so I'm going to do it in 10. I am Christopher Markou. I am a lecturer and Leverhulme Fellow at the Faculty of Law here in very currently rainy Cambridge. But before I became a lawyer, I did my first where I'm from. I'm originally from Canada, but I am the first generation European immigrants who emigrated to Canada after the end of the Second World War from Poland and the now former Yugoslavic Republic of Northern Macedonia. I don't want to get myself in trouble. But my interests have always been about big questions. My first two degrees were in religion and the history and philosophy of science. And I came to this point in my life where I had to decide between doing my doctors of divinity, as I was on track to do, or to go to law school. So I chose the thing that would make my mother the happiest and God the angriest. And here I am. But I'm really interested in artificial intelligence, not just because it's new and exciting, but it gives us a lens through which to reinterpret pretty fundamental questions that are always fascinated humanity, but I think that are becoming all the more pressing. So, as Yannick said, I will get the shameless plug out of the way. I have a book coming out based on a conference I hosted this past December here in Cambridge called Lex Ex Machina. The book is called Is Law Computable? To put it short, I've assembled a sort of team of all-stars, if you will, including Mireille Hildebrandt from the Vrije Universiteit Brussels, who Antoinette will know very well, because both of them did a lot of work that was central to helping me understand this area at all. But the book is really exploring the idea of what does it mean for something to be computable in the sense that implied by the theory of computation. But for something to be computable, we first have to know what law is. And depending on how you understand law, what you see it as, what function it has, your perspective will change. So I kind of come down on the side of French legal scholar Alain Soupiot at the Collège de France, who says that law has an anthropological function. And I won't sort of do disservice to his argument, but we wanted to explore this question, this idea of not just can machines play chess, can they play video games, but can they make judgments? about us, that is legally consequential judgments. And I think that on the basis of everything we're witnessing in the world today, these questions are taking on a very new urgency because they are no longer completely theoretical. But let's start with the police side of things. You've probably paid attention to the news, particularly in the United States, that there has been a call to defund the police. Now, while there are perfectly good and valid reasons to do that, and that there are perfectly logical and, dare I say, European strategies that could be adopted to make policing in that country far less brutal than it is, there is one catch, perhaps, that when you defund the police, cost saving and austerity measures will kick in, and then next best options will start appearing. For instance, one of the reasons in New York City that the stop and frisk campaign was ended was that it ended up detaining and allowed police officers to detain, questions, and search individuals who they suspected of being involved in criminal activity. This was particularly the case under former Mayor Michael Bloomberg, who has now repudiated his support of that. And 6 years later, after a disproportionate number of Black and ethnic minority people were stopped and frisked, the program was ruled unconstitutional, and the NYPD paid out a lot of money to stop the program. But lo and behold, what came out of it was a lot of data about young Black and Latino and ethnic minority men, oftentimes between the ages of about 18 to 30, being disproportionately represented in your data set. So while there's a lot of talk about ethics and bias and how do we create more fair algorithms, I really question the extent to which that is possible, both on technical grounds, but also logical grounds. Simply being, if an algorithm gives effect to the structural biases and prejudices of your society, we should not expect a racist society to do anything other than find a way to totalize and legitimize their racism. In fact, they've done just that. So one cost of defunding the police will be cost-cutting measures like COMPAS, something you might have heard of. COMPAS is an acronym for Correctional Offender Management, Profiling, and Alternative Sanctions. Basically, it's an algorithm that helps a judge assess the level of risk that someone poses and whether they should be sent to jail or released. Lo and behold, if your criminal justice system contains a lot of data about 18 to 25-year-old Black men being disproportionately represented in your data set, and that these people, for reasons well beyond bias or beyond any data scientist getting their hands on things, well, a structurally racist society will only encode those biases, pretending there is a mathematical or technical solution to mitigate those aspects of very complex social behaviors and historical consequences is foolish. COMPAS itself does not work. Despite not working, it is pretty much used in all 50 states. It allows Black defendants who are younger, who have been charged with less serious crimes, to be given higher or longer sentences than white defendants for more serious crimes with no antecedent history. Now, this is one of the most well-known examples, so I can cite it, but it's only one. But it brings me to what the point of my book is and what a lot of my research involves. Where do we stop with all this? What are the lines? I've been involved in this weird area of AI research for 7, 8 years now myself, so not nearly as long as other people, but even in my time, I've got kind of sick of talking about ethics and ethics frameworks because, as anyone was involved in the European Commission's high-level expert group for AI, it ends up wasting a lot of time if you let industry in and let them be overrepresented because financial interests will always trump any sort of others. So I wanted to retable the issue of red lines. Where are the contexts in our world, in society, where, for whatever reason, we should prohibit these tools? Maybe it's legal, maybe it's moral, maybe it's public policy, maybe it's just putting it to the people and saying, I don't want a machine making judgments about me here. Indeed, that's exactly what the GDPR has tried to do by ensuring the right to a human review. Or we could just look to Jeff Goldblum, the immortal wisdom from Jurassic Park. I think this kind of pervades the thinking around technology, and it always has. It's particularly acute now. We don't pay a lot of attention to questions of should. We are very focused on capacities, qualities, frameworks, ethical guidelines, as if these things are a panacea or a sufficient condition to do a bad idea in the first place. So, what do we want to go with this? The Industrial Revolution in Europe, certainly in the UK where I am, automated the physical domain of labor. Machines have long been able to do work better than us, faster than us, cheaper than us, and you don't have to pay them very much and they don't need to sleep. AI, however we might define it, poses the automation of the cognitive domain. That is, the human brain, the human mind, whatever it is that gives rise to this weird thing called consciousness that lets us do things like become lawyers, become judges, and indeed doctors, accountants, and so forth. Will people miss us? Us in the lawyer's sense? I mean, people will miss nurses, teachers. They'll probably want a doctor to speak to, but lawyers have been called flies on the hide of humanity, and we really haven't made a good case for ourselves. Will people really miss us? Have we made a case for ourselves? Really hard to know. Because there's one weird thing about the legal profession is that we're really stubborn and change adverse. Lawyers are not the most progressively minded people. Now, the reason that law has never been fast is in part down to the billable hours model, which means that speed has never been the overarching priority of law or lawyers, and that doing things quickly has rarely meant doing them right. But also lawyers can be pretty short-sighted. Richard Susskind's prediction in The Future of Law, which came out in '96, said that lawyers would be using email. It drew skepticism, criticism. Why would lawyers be doing email? That's for secretaries and trainees. Well, lo and behold, if there's any lawyers listening, I'm sure you know how much of your day is now spent on email. Lawyers are also expensive. Justice is expensive. There's also this weird classist thing here, specifically in the UK. I mean, judges wear wigs and whatnot. So maybe automation and automating human decision-making in some context has a case. The trouble is that the logic that we use to optimize AI systems and algorithms doesn't really map on to what optimization means in law. We don't really know what we're optimizing towards. Rule of law, justice, fairness, Rechtsstaat, whatever it is, can we really define it in a way that we would need to define it mathematically to allow an algorithm to optimize towards it? We could, but what we would lose in the process, perhaps, is what we consider sacrosanct about justice: flexibility. Flexibility is good. We need flexibility, and flexibility makes things brittle. Brittle things break. They break in often in unpredictable and dramatic ways. And more so now than ever in an increasingly plural society, we need flexibility because society is immensely complex and full, if not entirely composed of gray areas. Very few cases that judges deal with are black and white, even if they are deeply familiar. So law needs to be flexible or it will break, and so too might society. Maybe we're already seeing that. So in a time where there's a lot of reason to be cynical about people and to believe that machines are better than us in a lot of places and capacities, well, why shouldn't we take ourselves out of the loop and allow machines that could have the intelligence that we have, but inherit none of our biases and prejudices? Well, I think that conflates the output with the process. But this is not the first time we've thought this, and I will skip through the majority of what I have to say here, but AI is not new. If you were a lawyer in the 80s and 90s and you were at a law school or you were practicing, you might have called it legal expert systems. There was an earlier generation of scientists and lawyers who were very eager and enthusiastic to replace judges and lawyers with machines. The trouble is, it was difficult, to put it mildly. Applying tools like natural language processing to the legal domain is difficult. Why? Because law is a messy and imprecise medium. It takes place through this thing called natural language, this messy, deeply semantic and subjective thing that allows judges and lawyers to twist language, sometimes to the frustration of people. But that same use of language, that rhetorical reinterpretation, even if, dare I say, judges get it wrong sometimes, is what allows law to evolve, and it's what gives things flexibility. If we wanted to predict every case, indeed, as people have done with the US Supreme Court, who would have predicted that last week the leading opinion in the LGBT rights case that saw LGBT persons be protected under the Civil Rights Act would have been written by two conservative justices, one appointed by Donald Trump, the other by Ronald Reagan? We wouldn't have seen that coming, but maybe we shouldn't have. This has not stopped physicists like Max Tegmark to describe law as basically just computation. Judges like Richard Posner to say, hey, if you're a conservative justice, you should love AI, because if conservatism is defined as believing that nothing should ever happen for the first time, a system that only uses the past to inform the present will ensure nothing ever happens for the first time again. But this is what worries me. Scholars like Eugene Volokh, who say that if a medical diagnosis comes out of a machine and it's good, well, we should call it intelligent. Likewise, if a machine writes a judicial opinion, well, we should accept it. I find this truly disturbing. I teach undergraduate students, and I have to talk to them about jurisprudence, rule of law, and philosophy, and I have to convince them that it's the process that matters. It's not merely the output. But if I'm taking people like Eugene at face value, who I think is representative of a understanding of law as an output, not as a process, maybe judges don't actually matter? So I'll skip through what might be familiar to you, but suffice to say, building a robot judge is one component of this legal tech enterprise, this widespread use of AI and AI-adjacent techniques to help lawyers do lawyerly things like billing, contract drafting, discovery, review, blah, 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 blah. Of course, this has always been the dream, and personally, I'm not terribly interested in what lawyers do in service of their work. I'm very interested in what happens when we have confidence in these tools and say that they are good enough to be used in the real world. People are indeed doing that. One of the biggest enterprises right now is using machine learning and AI to predict what judges do. And it seems, well, you might be able to do it with the Supreme Court, but you wouldn't have seen the decision last week coming, or both decisions in the US Supreme Court last week. You can seemingly do it with the ECHR, but what are you really doing? What are you really doing by connecting data points that represent mental states, emotions, intellect of judges, lawyers, that takes no account of the mood of the courtroom, press, reporting, politics, and all these forces that none of us are immune from? So I'll close with this, and why I have skepticism about the idea of ceding human discretional authority to machines. It's really hard to justify humanity. If you want to be cynical about people, watch the news. It's very easy. But because I don't want to slide into nihilism, here's what I'm starting from, and I think by doing so, maybe I'm being a better scientist than most of my scientific friends. There is no science of the future, despite what economists tell us, despite what computer scientists tell us. We cannot prognosticate very far into the future. We could probably predict the weather tomorrow, but not next week. Simulating legal judgment is not the same as legitimate legal authority. Regardless of how fancy and how technically sufficient your tool is, no one elected it, no one appointed it, no one accredited it. It did not educate itself, even if it underwent a deep learning process. Learning is one component of what lawyers and judges, or indeed doctors and accountants, need to do. Their personal conduct matters. So I'll take a lot of this legal tech stuff more seriously when I start seeing the people who are building these systems subject to the same kind of professional regulation and scrutiny that I have as a solicitor or a barrister, that a judge has, or a doctor, because guess what? Unless we find a way to connect people to the consequences of what they do, they will just do whatever comes to mind. And finally, and perhaps most importantly, in Europe, a prediction can quickly become a decision depending on how confident you are in your prediction. We cannot predict the future. We should not, for reasons mathematical and logical, be able to model what judges do. Indeed, in France, they have prohibited this, the use of judicial analytics. So I think that, to sum up here, and I apologize for going over time, that if Europe is to have a place in this discussion, it is not going to win an arms race by outspending the United States and China, nor should it try. What it should do is what it's always been good at, being the adult in the room. What does that mean? It means not allowing promises of futures of vast technological prosperity to overshadow even a modicum of democratic deliberation, that is, from your people, about what you're doing with their tax revenue and what you are doing with their futures. You cannot automate people's futures out from underneath them, but you also should be really, really careful about the ingress of technology into the legal system specifically. I mean, tell me what you think about Twitter and the media landscape and politics right now. I'm sure at the Council of Europe it's all rosy and everything is fine. Maybe there are reasons that we should be really, really skeptical of these things. And even if it means surrendering potential benefits because we cannot adequately quantify the risks that they pose, maybe that's the basis of good policy making, whether you call it a precautionary principle, a Coleridge dilemma. Maybe we should answer these questions, or at least put them to people before we make them for each other. Because in the hands of Estonia, a robot judge might seem interesting and exciting, but in China, where we're already seeing 1.3 million cases processed online, they didn't really have to ask anybody. I don't think we should go down that road. So thank you for your time.
Thank you very much, Christopher. Do you hear me? Yes. Thanks a lot for bringing us back to these fundamental questions. This question we have to explore again through the technology of artificial intelligence. Thank you for recalling us that law is flexible. You've spoken of Alain Supiot, but you could also mention Carbonnier, Flexible Droit, and Le Flou du Droit by Mireille Delmas-Marty. And this is something I will again recall to my students because they don't want to hear that, but we have to recall it more and more with simulated judgments that will appear or that could appear in the next time, and that will, as you said very clearly, that will never be a decision. A prediction is not a decision. But I think here at the Council of Europe, I mean, I'm not from the Council of Europe, but I think people are very aware here in this building where we are and in this community, in this European community. So I think we can be very confident. Thank you again, Christopher. And I now give the floor to Yannick, because I think we have some questions.
Yeah, very quickly, thanks a lot again, Christopher, for that. I just want to mention that in the Council of Europe, we have this European Charter on the use of artificial intelligence in judicial system. And I'm sure that, Christopher, you know that, and it already raised some kind of questions, but maybe we need more binding things. And indeed, we have already some questions, but we're running late. I will save that just after that. And I would like to give the floor to Antoinette Rouvroy now, because I read for the first time Antoinette in 2015 with an article published in 2013 about gouvernementalité algorithmique, algorithmic governmentality, and it's quite amazing because it's of course a kind of actualization of Michel Foucault's work about governmentality, but I'm sure that Antoinette will speak of that better than me. So Antoinette, if you would like to take the floor now.
Thank you very much for having me. It's a real pleasure to be there this morning in this non-space, but not without address. Yes, indeed, I've been working for some time now, so maybe 10 years now, on a kind of hypothesis or a research line that indeed I have called with a colleague of mine, Thomas Berns. We have called that hypothesis the hypothesis of algorithmic governmentality. By that strange word, what we mean is, in fact, it went from our acknowledgement that today data, either personal, anonymous, relational, or contextual data, are really the new coordinates of social modelization in almost all sectors of activity and governance. It is on the basis of data, of digital data, presenting themselves as a kind of second skin of the world, of the social world, rather than on the basis of institutional, deliberative, cultural, and symbolic processes, that the categories through which individuals are classified, evaluated, rewarded, or sanctioned, or through which the merits and needs of individuals and groups are evaluated, or through which the opportunities or dangerousness of the various forms of life they inhabit are detected. So it is a shift that for a lawyer is really a challenge, because law is nothing else than a long and slow sedimentation of science, meaningful science and text in a civilization which is based on human language. And we are really on a threshold of a shift towards another civilization, a civilization of signals, digital signals, and algorithms. So that's a big challenge for a lawyer, a very semiotic challenge, I would say. The aura of objectivity and the reason why this algorithmic governmentality gained proponents is that, in fact, algorithms appear blind towards what makes the singularity of each life and what inscribes each life in collective context. Instead, it is focalized on what links each life statistically to impersonal but predictive profiles. And that is precisely what confers to algorithms at the same time an aura of objectivity and impartiality, but it is also what renders algorithmic predictions, for example, very difficult to either justify or contest. So, of course, algorithms are not descriptive of any real world reality or even or person. In fact, of course, just like law, algorithms produce synthetic realities, like law produce presumptions, for example. Algorithms produce profiles or scores, which are proxies in order to deal or neutralize, in fact, the limits of linguistic representativity or representability. The location of the limits of representability, which are also delineating a space of contestability, critique, and political imagination, is indeed different in legal and digital universe. Now, so for that reason, I take the algorithmic turn as a symptom of a change of civilization. And what is that change? In fact, and what does it mean for the law? In fact, that change is the idea that, in fact, we are confronted to a radical crisis of representation. It means that we don't want representation as such. It's not only, that we find that representations are unfair to some group, or that they are unrealistic enough. But what we don't want anymore is the lateness of representing reality. It's a third for pure immanence, and that for the law is really a fundamental problem, because I take as a hypothesis that, in fact, what matters for law, what makes it important, what is important for law, is a triple disadjointment. What I try to contrast in my work is a kind of metaphysics of pure presence, of the digital presence, to a metaphysics of a difference which is specific to the law. For a judge, for example, there is a distinction between a subject, a legal subject, and its behavior. Whereas for algorithms, in fact, subjects are deduced from data, meaning from behaviors, from relations between a subject and its environment. Subjects are deduced from profiles, are calculated. So there is no disadjointment, and even profiles, because they are meant to be predictive, anticipate to the advent of subjects and shortcut the possibility to add for persons to arrive as or to rise as legal subjects. Subjects are deprived from the possibility to give account of themselves because they're already predicted. When you are already predicted, you cannot say anything anymore for yourself. A second disadjointment, which is very crucial for the law, is the distinction between law and justice. The state of law, state of fact, is never just. A judge knows that when a judge has to decide about a case. The judge tries to approximate justice, and justice can never be registered into data about pre-existing situations, because justice is a principle of perfectibility of the social. So that this distinction, this junction between law and justice is absolutely essential to what law is about. For that reason, it is impossible to compute law completely and to just by processing algorithmically past jurisprudence, past decision, just the result of that computation says nothing about justice. That's the reason why you may have completely objective algorithms, which, if it was possible, which I don't think is possible, which is really fair, accountable, and transparent, even if that was attainable, it would still not be just. Algorithmic objectivity has nothing to do with justice, because justice is a dimension which really exceeds the mere optimization of a state of fact. Third, justice requires a distinction between the world and its representation, because justice is not a word, it's a verb. Justice is the sum of the struggles about representation, struggles to make law evolve, and so that technical ideology of big data, presupposing or pretending to exhaust the world in all its dimensions, both past, present, but also future, is just incompatible, or just it's a closure of that gap, that essential gap between the world and its representation. For that reason, I would say, like Alain Suppiot, who is also one of my references, that in fact Homo juridicus is really irreducible to Homo numericus. It's insoluble in Homo numericus, because just as Alain Suppiot said, in fact, about the anthropological function of law, which is to tie together the biological, the social, and the symbolic aspects of human life, is just unattainable when human life in all its dimensions is taken to be mere flow of fragmented digital data. So whereas we have that illusion that using algorithms and big data give us the just measure of things, because it's an apprehension of the world in high definition, it's also an apprehension of the world in high dissolution. No shape, no form, no subject, no object remain in the eye of an algorithm. What algorithms produce are purely speculative space of opportunities and risks, and these new spaces are open for new kinds of predation of the future. And it's the new kind of power that arises through algorithmic governmentality indeed has a new target. The target of that power is not the subject anymore. It's not even objects. It's the excess of the possible over the probable. It's the pure virtual. And for that reason, it really forecloses any possibility of justice, because it's a closure of the digital upon itself. So for that reason, we have to find new ways to protect a specific dimension of the human being, which is its the dimension of potentiality. The fact that we are never completely contained in our past, that we are irreducible to our behaviors, and that we need and we have to confront ourselves in a public space, meaning a space that has not been preempted for us, that has not been adapted to our own individual needs. We have to decide collectively about our future. So that's the reason also, I think, why Jacques Derrida said that a judge, for example, that would follow the result of a calculation is not a judge. It's a calculatrice. It's a machine to compute. So as a conclusion, I think what I can say is that we have, as lawyers, to be very careful to indeed use these machines, which are also extraordinary because they have capacities we don't have, to detect regularities of the world which would escape our perception. We have to use them, but we have to be attentive to our own mode of veridiction and creation of reality. We cannot live as lawyers as pure seismographs. Neither politicians can. In fact, also we cannot live in space, in hyper-speculative spaces, because we are beings who are obsessed with truth and truth-finding and processes of truth. We have to produce and stabilize truth. Truth is never in the data. It's never immanent. Truth is something that happens to facts. Truth is not in the facts. Hermeneutics is really important. And maybe the distinction, the most fundamental distinction between the learning machine of the law and the digital learning machine is that the learning machine of the law is a dogmatic snapshot of itself, which organizes by itself its proper process to revise its own production. It's the hermeneutics, whereas algorithmic machines, in fact, confuse hermeneutics and seismography and do not leave space for interpretation. So both legal and digital learning machines generate synthetic truths. But we have to be very, very careful about how they do that and what these kind of truths mean for us, for humans. Thank you very much.
Thanks a lot, Antoinette, for this very rich and insightful speaking. And I think there is a lot more to say, especially about the misunderstanding between facts and computation of facts and interpretation of law. I think this is truly different. And one last thought is that I think we search today simple solution to solve complex problems, and machine learning and computer can solve some problems, but not everything. So we are running late. I'm very sorry for that. And I would like to give the floor to some question. I will give the floor first to Charlotte Adenaudion in a moment. She is head of unit of internet governance. She will ask a question to our three speakers. And the conclusion, I want to mention that, will be provided by Claudia Luciani and Diane Clayson, directors in the Council of Europe. They are with us, so we try to speed up a little bit. Just some words about the question that have been raised by the audience. We have some quite interesting questions. We will not explore all of them now. I will let the floor to Charlotte, but just something. For instance, some technical solutions seems to exist to try to solve some bias. This is again a discussion of expert. I saw one question about the low degree. Do we need a low degree or not in near future? Will my low degree will be useless? This is kind of provocative question, but quite interesting. And just one last thing. Also, I want to show you, we ask a simple question. What do you think about the use of algorithm for public decision making? We have a kind of cloud of words. There's not so much participants. You can continue after that, but you see there is some fears, at least, in public opinion. So I will leave the floor now to a more, that live question, and it's my pleasure to welcome my colleague Charlotte Aldenauer-Dion to raise a question and ask a question to our three experts. Charlotte, the floor is yours.
Thank you. Good morning, and thank you for this opportunity. It has been fascinating to listen. I would like to ask a question about oversight. Within the Internet Governance Unit, we have been working with an interdisciplinary expert committee called the MSI Aud, which explored the broader human rights impacts of automated means and prepared two Council of Europe instruments that are of relevance to this discussion today. One is the Committee of Ministers Declaration on the Manipulative Capabilities of Algorithmic Processes, adopted in February of 2019. Which warns of the growing capacity of machine learning tools, not only to predict choices, but to use that predictive knowledge to exploit vulnerabilities and to shape and influence our choices and behaviors in line with vested interests and ultimately affecting the very basis of the Council of Europe values, which is individual autonomy and dignity. And the other instrument is the Committee of Ministers' recommendation on the human rights impacts of algorithmic systems. This was adopted a few weeks ago in April. And this recommendation risks the very distinct impacts that algorithmic systems, in particular multiple systems that run in parallel and interact with each other, can have on human rights, and calls on member states, A, to develop effective risk management mechanisms, and B, to establish regulatory and supervisory frameworks that can ensure that human rights violations are prevented, detected, first of all, and remedied. So both documents really call for more accountability and oversight regarding the use of algorithmic systems, particularly in the public sphere, where they have legal consequences, like Christopher said, and also flag that the speed and scale of algorithmic development may well outpace regulatory control if it is not addressed promptly. So my question to you would be, how you think such oversight bodies could best be structured to effectively promote human rights compliance, and how their independence and democratic legitimacy could best be assured. Thank you.
Thank you very much, Charlotte, for these questions. I suggest to give the floor first to Marine for answering this question. Is that okay for you, Marine?
Yes, thank you very much. The question of the oversight bodies and the democratic participation is really I think the main core of what we are working on right now in the Council of Europe. Well, we managed to invent something for data protection. So there is already something existing that is working, and maybe we could think about what we did, how we built this system of oversight in the use of data to build something similar for AI. because we need to build something that implies at the same time a lawyer, sociologues, computer scientists. We need a lot of complementary competencies in order to be able to understand all the aspects of these tools and all the implications. And I think the democratic participation is growing now. I think it's a question that is now more and more known. And I mean, we've seen the debate that happened when there was an idea of using Facebook public information to cross-check them with tax services in order to detect tax fraud. The reaction of the public was really strong. So I think this is growing. I think there is something to build in terms of structure, but we are on the way, and maybe the two of the speakers will have some more ideas on this question.
Thank you, Marine. So this is an ongoing process. Christopher, would you like to add something about oversight bodies?
So the first thing that comes out, first of all, I don't think there are perfect solutions to a lot of these questions. I think that a lot of these questions about governance, regulatory oversight, design, I think we're dealing with a range of imperfect options, at least by how we currently adjudicate them. There's a saying, it's a Latin saying, in English it's who watches the watchman, in French, qui regarde les veilleurs. I think that's really what we're talking about here. You could appoint a body to provide ethical oversight, legal oversight, whatever you want to call it, who then oversees them, and then who oversees that body. And you can imagine that you get this Matryoshka type doll thing of oversight bodies. And without wanting to get myself sued, I have been involved in discussions about, and I'm sure people listening are too, about those bodies. And I mentioned the high-level expert group, and I think that that's a pretty good case study of how not to do things, maybe. I mean, certainly it was done with the best of intentions, with a lot of the right people, but any, ethical advisory board that has more than 50% industry composition, I'm just going to go out on a limb and say their views are going to be represented disproportionately. And I think practically, Professor Metzinger in Germany has been really clear and outspoken about this, that it was just a waste of time. It was ethics washing. It was using this pretext of ethics and getting a lot of smart people from the right institutions together in a room and saying, look at all the smart people we've talked to. We've done all the right things. They're all ethical people. I just think it's hubris, frankly. Not to say that we shouldn't have deliberation or there isn't, philosophical questions underpinning this. I just think that the longer we forestall taking action, the more passively we actualize a paradigm that we're not going to have any control over. So I think the challenge from a regulatory perspective is decidedly, I guess, un-European in the sense that this laissez-faire attitude of what's good for industry is good for all of us. I'm just going to show my cards and say I don't think that works anymore. I think they've had a go of it, and they've kind of destroyed the world. And I think the stakes and consequences now, if we take them at face value, whether it's existential risk, algorithmic bias, or whatever it is, if these are not serious enough risks, or there are not enough unknown unknowns to justify proactive regulatory intervention and to do what the high-level expert group was trying to do, identify red lines. Red lines, that phrase became critical concerns once the high-level expert group had that document redrafted. That's one way of lobbying and watering down critical concerns of democratic consequence by allowing industry to sort of do what industry does. And again, I'm not here to throw stones at Google because I use Google, but if you want to solve problems, sometimes you just have to make tough choices on the basis of incomplete information, what seems logical at the time, not giving industry the benefit of the doubt that they'll self-regulate. Because Wall Street did that, and that didn't work out.
Thank you, Christopher. So you mean red lines might be more important than oversight bodies, and oversight bodies should have to keep in mind that they cannot legitimate anything that has been determined as a breach of a red line. Thanks a lot.
I think practically AI governance is a wicked problem. There's a very good chance, despite your best intentions and efforts, we get it wrong anyways. So you have to prepare for that eventuality that, you know, despite all the time and attention and investment that is being made and good people being involved, let's not kid ourselves. We have gotten major technological paradigms wrong before with consequences. I'm sure there's another webinar on global warming that the Council of Europe's done. And if we had the foresight to say, fossil fuels might be dangerous, we wouldn't have locked in a paradigm that we're struggling to get rid of. And I think, I'm not saying AI is going to kill us. I'm not of that camp, but like there is a camp that says that. So let's take them seriously. That means asking people, where does this make you feel uncomfortable? Where, you know, GDPR says you have a right to a person making a decision. Color me a humanist, but like I think that's the conversation that should be had, not getting more people with like PhDs from Cambridge in a room. I'm very happy to show up, but like you probably shouldn't listen to me all the time.
Thanks a lot for this very clear and straight explanation. We now turn to Antoinette. Antoinette, would you like to give us our opinion to the question of Charlotte?
Yes, indeed. That's a tough question. Indeed, we all feel that there is a need of a kind of oversight or setting limits, and we don't know how to do it. Is it the law? Is it ethics? Is it something else, self-regulation? As a matter of fact, I believe law is the only very effective, potentially effective way of redlining anything. You know, we have already very hard time enforcing already enforceable and fully effective laws, especially human rights laws. So how could we expect big companies and governments to respect less enforceable ethical rules or things like that? I don't think it could work. Also, and that's tricky as well. The notion that we could have ethical AI, for example, is very, very problematic, because if we say we have ethical AI, it really could reinforce a techno-solutionist approach. Saying, well, for example, if we have perfectly objective, fair, transparent algorithms, why then keep a judge, a human judge? A human judge could only impose biases on that perfect algorithmic solution. So it's reinforcing the idea or the kind of essentialism or the kind of sentiment of immanence and perfection of these dispositives. In fact, whereas what we need, like in law, for example, I believe that the most fundamental criteria of legitimacy of a norm is its contestability, the possibility to contest and to say, okay, this solution or this decision that has been taken is not correct. It's not correct not because it has been taken on the basis of an automatic recommendation which was badly designed. That's not the issue. The issue for the person who suffers from a decision is not the issue whether how the decision has been taken, but whether that decision is just and fair with regard to his own or her own situation. So the problem is that there is a kind of reductionism in our critical approaches usually. Well-intended reactions or supervisory bodies and so on is to ensure transparency, accountability, and so on, but accountability, transparency, and fairness of a technical subsystem, of a black box, whereas what has to be fair, what has to be judged, accountable, and transparent is not the black box, it's not the subsystem, but it's the whole human system, including these technological tools. So let's not succumb to that reductionism. because it's easier, of course, because then we can blame the machine or the people who build the machines or even the data, or we can blame something else than the person who has decided. So that's, I think, most important. And of course, in order to allow for, at the same time, justification, human justification and contestability, there is, of course, the need also to make some parts of the algorithm transparent, accountable, and so on.
Many thanks to our three experts for these answers. Before to give the floor to Claudia Luciani and then to Jan Claessen for maybe some question and conclusion, I would like to see if the President of the Parliamentary Assembly, Mr. Dams, is always connected with us, and if he has maybe some thought or question for our experts. Mr. Dams, please.
Well, you hear me?
Yes.
Yes, we do.
Yeah, well, I'm not legally trained, so there's a lot of JWBs. I don't know how you say that in English that way, but there's a lot of stuff in there that I just don't even understand. With all due respect, I'm an MBA trained person, so I was a little bit lost. One thing that did strike me, and I do apologize to all of your brilliant legally trained persons. I'm just a very normal citizen concerning that issue. But something that struck me is it's all about predictability. But then it came to my mind that no case is identical. How can you predict something that in no instance will be identical? That is something that boggles me. I don't get that. And to me, if law is all about judging on a non-identical situation, be it merely because the person in question is not identical to any other one, why even bother about predictability? That would be my question.
Thanks. One of our experts, Christopher. I see Christopher raising the hand. Please.
So I'll take this just because it's what preoccupies the forefront of my attention. So I'll say first, because he was mentioned twice, Alain Soupiot wrote, I think, one of the best books on this subject. In French, it was Gouvernance pour nombre, or Governance by Numbers. And there's a section in there where he talks about human labor and time and how the shift from the sort of mechanical clock to the computer resulted in this reconceptualization of human labor, where we began to index our time and work to the precision of the computational clock. We didn't work for an afternoon until the sun went down. We worked for 5 hours and then took a 45-minute break. This had a knock-on effect to how we conceive time. So why does this matter? So let me put this even more plainly, and if this sounds bonkers, then you can leave. It's really easy to talk about artificial intelligence and computation and computers in this instance as if it is a new version of what has come before. It's a very good lawyerly way to approach things, because if you treat everything as new or you try to apply novel rules to something, what you usually do is you realize, oh, that thing wasn't as new, as exciting as we thought. Because you can go back throughout history and see similar debates about the railways, the telegraph, telephones, the internet, the atomic bomb. Basically, if there's one lesson to be learned from our history of analyzing technology, it's that we tend to think things are new, crazy, and exciting, unexplainable, and they need to be addressed right away. And then we realize, oh, contract law exists, and that might be adaptable. And that's usually the best way to try and approach these things. So what was difficult about AI is being cognizant of this historical long view that, like, we shouldn't reinvent the legal wheel every time something new and exciting comes, with this realization that, like, oh, this thing might actually be fundamentally distinct. It might be different from what's come before. And I'm here in Cambridge, and in Cambridge, like places like Oxford and Silicon Valley, and indeed parties in the European Parliament, let's not kid ourselves. Transhumanism is the long-term goal of what we're talking about here. Building intelligent machines to play chess and to replace judges are fragments of what we might call the cognitive domain of human beings. So the question, I think, that's really difficult to wrap our heads around is, we've evolved as a species over hundreds of thousands of years. We've developed this natural language that we use to resolve disputes, talk and argue and give webinars. So if you listen to people like Noam Chomsky, this language thing that we use, maybe it's biologically innate. Maybe it's something that is hard-coded into human beings. We don't know. You can have to talk to linguistics about it. But if it is, feminine-centered legal system and sphere, because the consequence is that maybe technology conceived as a system, a social system, in the way that people like Niklas Luhmann would conceive it, maybe this is just our evolution and our discomfort with technology, our fear, our worry about futures of automation and joblessness are us just reconciling ourselves that maybe we're being selected out of the evolutionary process. I know people here and certainly internationally that will say just that the singularity is not just inevitable, we should hasten it. It's desirable. We shouldn't just want robot judges, we need them. And that is the ideological orientation that orients Silicon Valley, the tech industry writ large. And if you don't want to take my word for it, there was a BBC documentary in 2011 called All Watched Over by Machines of Loving Grace by Adam Curtis, won a lot of awards. This argument has already been made, and all I could say is like, yeah, you should probably watch that, because what Supio was telling us in his way was we are increasingly bending ourselves to fit computational models and index our expectations of ourselves, whether it's lawyers, judges, in how many cases, to machines. I don't know where that natural comparison came from, but that now seems to be the paradigm we're in. And guess what? We're going to lose that one. So the goal is not trying to come up with increasingly elaborate ethical or philosophical frameworks. I have philosopher friends. I love them. They're great people. But we have to make real world choices at some point. And I think that that's where the European Union should come in. You're not going to get it from the US. You're not going to get it from China. If you want to have a meaningful say no to things and ask people what they want done so that you can do AI smarter and better, not outspending people you're not going to outspend.
Thanks, Christopher, for this word. I saw that Antoinette wants to take the floor also, but I would like to give the floor first to Claudia Luciani, maybe, for a question before the word of conclusion. Claudia, please.
No questions, I have a million. I concentrate on a few takeaways, Yannick, so if you want the first to have Antoinette, that's fine with me.
Okay, thanks a lot, Claudia. Please, Antoinette.
Yes, I just wanted to respond to that question, that very nice question. Why bother about prediction if it doesn't work? Because there is a recalcitrance in life to any kind of excessive organization. So of course it never works. But in fact, it's not that it works. The question is whether it works or it doesn't work. It doesn't matter so much. It allows for, it's not predictions are not true nor false. They are just reliable enough to justify specific strategies of actions which are optimal for some actors at a specific time. And so for that reason, these predictions are in fact performative. If, for example, they allow anticipative strikes against a suspect target with a drone, the target will be dead before even thinking about committing a crime. So it's very performative. It doesn't observe the world. In fact, it reacts to the signals sent emanating from the world on the mode of reflex response, but it also sends specific signals to the world in order to manipulate and to choose among all possible futures, one future, the optimal future for the person who benefits from the algorithm. So what does that mean for individual person, for the legal subject, for example? It means, from my point of view, that there is a dimension of the legal subject which was not threatened before, which is now threatened. It's the dimension of potentiality, of puissance, the capacity of a person not to behave like it has been predicted to probably behave. It's that, that shortcut of in French we say réticence, the capacity that we have to not do all we are capable of. We will be taken by the algorithm as if all our potentialities were already actualized in a way. So that's what I call preemption. Preemption is not even prediction, because it doesn't say what the future would look like if there was no intervention, but it intervenes directly on the future. That's the reason why algorithmic governmentality is really a new way of exercising power and on a target which is absolutely general, which is not superposed to any experienced category of person. It's not the ethnicity, not gender, not any kind of vulnerable criteria, but it's the uncertainty as such that is the target. It is a target which is completely impersonal, which is absolutely general, and which really bypass the legal subject. So that's what I would say about why prediction still matters, whereas although it doesn't work.
Okay.
Could I say that for?
Yes.
Can I just say two things for those with MBAs, just to translate for those with MBAs? Is Yanis Varoufakis watching this? If he's not, okay, good. So in the absence of a complete account of human behavior, what is the only explanation we have for reason for groups? Called game theory. Game theory is the core of how machines think, reason about the world. We don't have an account of how to think about how three people might behave. We have to model them as rational agents, and that's how we get things like the prisoner's dilemma. Guess what? If we do that in every single human interaction, whether it is an autonomous vehicle navigating a non-cooperative environment with people and trees and bicycles, if you totalize an AI decision-making paradigm, you totalize Yanis Varoufakis. I'll just say that in the hope that I don't get assassinated.
Thanks a lot. Thank you, Christopher. Marine, would you like to add something to this stage?
Just two words just to complete what has been said. I think that's true. It doesn't predict what is going to happen. It just gives information about what happened before with similar cases based on the precise data you gave to the machine. So I think what is really important, and it has been said by Antoinette Rouvroy, it's to really explain what the machine does, really tell what the result means. And that's the way we are going to, at the same time, enable people to say they don't agree with the results and have them maybe take into account this information at the right level, not as a prediction, but as an information about past, about maybe statistical learnings we can have from those data, but not as a prediction. I think that's the most important thing about AI, to be able to understand and explain what it really does.
Yannick, you're a judge, right?
Yes.
I tell my students that a machine is really good at making the decision you made yesterday and the homework you did the night before. That's pretty much all it is.
Thank you, Antoinette, for a very last and very short intervention.
I just wanted to add to that the difference when someone takes a decision about yourself and makes a big mistake, you can notice the level of the mistake. You can tell, what kind of mistake, if it's yes, if it's something else, When a machine takes a decision about yourself, insofar as you can call that a decision, I wouldn't call that a decision, but when a machine emits something about yourself, you can tell it's wrong, but it's impossible to tell the level of the error, to recognize the level of the error. And that also puts you in a situation of extreme vulnerability, because it's very difficult when you cannot understand the level of the error that has been made while making a decision about yourself. It's very, very difficult to know in which language to argue with the machine, or with what kind of argument, because it's just, for you, it's just nonsense. It's statistics. It's inductive. It's not deductive. It's not translatable into a linear language that humans could understand. So that's also an additional difficulty, I would say, an additional vulnerability of people when they're confronted with these kinds of algorithmic decisions.
Thank you, Antoinette, for these last words. It was absolutely fascinating. Thank you very much for all three experts for sharing their research, for taking their time, for giving us an appreciation of their thoughts. I will just announce the next Artificial Intelligence and Law Breakfast, which will take place probably at the end of September or beginning of October. Probably it will still be on a virtual basis like we do today. And the thematic of this next meeting will be certification of artificial intelligence tools. So now for very final concluding words, I will give the floor to the directors of the Council of Europe. So first to Claudia Luciani and then to Jan Gleisen. Thank you very much to the experts again.
Thank you very much. It's been a fascinating discussion. So again, questions, there's still many more probably than when we started. My part, I just want to highlight what I found with three maybe takeaways and the two injunctions that I heard loud and clear from the experts. The first was very nicely reminded about the meaning of justice. I think this was eloquently done by all the experts. It's an anthropological function. And at the Council of Europe, we know very well that for us, justice remains a struggle, something we tend towards. So we do not want to mix, certainly, the output with the process. The process is, for the Council of Europe, what is extremely important. So the process and how just it must be, and the fact that this remains a fundamental function for our societies and for our continent. The second is about the notion of confidence and trust. I think, as you said very well, the public, the citizens must keep the trust in the humans, first of all, and indeed, sometimes you wonder how they can still do that. So they must keep the trust both in the humans and in AI. I think both need to earn the trust of the citizens in their different functions, in their different role. And therefore, contestability must be possible. We must be able to contest the decisions that are not human and are AI, and we must understand where the error comes from. The third takeaway for me is the importance of keeping the focus on the subject. So this reductio ad unum is very dangerous, even if the desire of limit uncertainty, as Antoinette says, may deserve all our attention, but we cannot, of course, we are, as you said, Antoinette, irreducible. And this function of becoming seismographers may be interesting at times, although I must say, for me, the biggest disappointment of even that function came just recently with COVID. AI was completely useless. We had to go back to the subject, to the clinical examination of the patients in order to understand, and we're still not understanding, what we can predict or what not. So COVID has been a very powerful reminder of all the limits of any prediction without the clinical examination. Again, literally, the subject. Now, the two injunctions that I get from you is first about concentrating on the red lines. This is what we're trying to do at the Council of Europe, with imagining how we can put those red lines in a legal instrument that would be binding. And the second is the sense of urgency that I heard, and not to waste too much time on discussions with, and also about the format of the partnerships we should, or who should be in that famous room. The adults in the room, we must pick our adults well. Of course, we work with our member states. But I heard that there's a sense of urgency because indeed, as it happened with the dangers of smoking. For a long time, we were waiting to hear the experts. We then understood it was urgent to have rules to stop the danger of smoking. I think we are in the same urgent situation, so it's time that, of course, we give it our best shot at the Council of Europe to introduce regulation. These are my conclusions. Thank you very much.
Thank you very much, Claudia. Now I will directly turn to Jan Kleijsen for the very final words.
Yes, thank you. Thank you very much. I won't name everyone because that would take too much time. So a great many thanks to all. Just to pick up where Claudia left for a moment, to show that there is difference of opinion in the Council. I wouldn't say that the AI was totally useless on COVID. I would say actually on the contrary. It was very useful in sharing research and detecting a number of things. What it didn't do, it wasn't the magic wand, it wasn't the silver bullet that many people thought it might be in finding a solution straight away. However, it did contribute. But to come back to the subject of today, first of all, law. The President of the Assembly mentioned it. There was a lot of talk about law. I think Christopher brought in an extremely useful reminder of what the law is about. Law is about connecting people to the consequences of what they do. And that is something that strangely is very much missing from the digital industry. A lot of products and a lot of tools have been rolled out, have been implemented, are being used by governments without any proper legal regulation. The bicycles we use are subject to much more standard controls than the smartphones we have in our pockets and use almost constantly, but the consequences can be much greater. In order not to be too long, I think it is essential that we decide very clearly, because the red lines were mentioned several times. It is important to decide what we want AI to do, and also very important, what we do not want AI to do. That cannot be left to ethics. That, to come back to the definition of law that Christopher gave, we must connect people to the consequences of what they do. And therefore, legal regulation is extremely important. That is what CAHI, this special ad hoc committee of national experts that has been set up, is going to do next week again. And we hope to make good progress because it is urgent that we tackle this. Because the President of the Assembly also asked about the prediction of algorithmic systems and AI. Predicting is one thing, prescribing is another one. And unfortunately, by delegating more and more decision-making to automated systems, we're not only letting those systems predict what will happen, we let them prescribe what should happen. And that is something I think we want to think about carefully. So thank you very much for your attention. I hope you enjoyed it. Thank you very much.
Thanks a lot, Claudia and Jan, for this talk. And I would like to give, for last word, the floor to the President Dems. And just one thought, I want to quote as a conclusion Antoine Garapon, which is a French philosopher and magistrate. He said that the predictive systems change freedom to destiny. Maybe we can think about that. President Dems, please, the very last word.
A lot of stuff. And thank you all for trying to enlighten us non-legally trained persons. But I do know a little bit about algorithms. So just one thought. I mean, the way I've been told is an algorithm is a thing that if you put something in black box, something comes out of the black box. If what you put in is identical to any other situation, the output is also identical. And as I said, there is no identical situation. So that's something that bothers me. Secondly, if you put a situation in terms of judgment through an algorithm, something will come out. So my question is, how can you appeal to a decision? Because what you put in will be the same, and so what will get out also will be the same. So what about appeal? I don't get it. I mean, but again, this is because I'm probably not legally trained, but I think it is an issue. And so I thank also Jan for his last remark. I mean, predictability, if it becomes instructive to a certain extent, basically you have machines organizing a normative society in which we need to function. Now, what is about human beings? It's because we are not to be catched within all the norms, because we are innovative, we're creative, we change our own world. And so that is what is making me a little bit afraid about, artificial intelligence in the broad way. And this is why I cherish very much all of your expertise to take it on in our debates in the Parliamentary Assembly. I hope that we can get a lot more expertise. And if some of you would bother to give me like a crash course in some of these legal issues, that would be very helpful for me to have the debate in our Parliamentary Assembly. Then again, this being said, in our MBA courses in the Solvay Business School, we did get a little bit of law. Apparently it's not enough. Well, thank you very much for your expertise. I hope we will get a lot more, because as a Parliamentary Assembly, we would like to set the foundations of really setting out those red lines, because at the end of the day, what we want to do is make a better life for the citizens, and not one where we become robots because we are managed by robots. Thank you.
University of Strasbourg and its law faculty will always be happy to welcome you for additional legal education. Thanks a lot.
Thanks for everything. Goodbye. See you in September or October. Bye-bye. Bye-bye to you all. Thanks a lot.
Goodbye. Thank you.